Okay, well, hey, we're back here in the property class again. We're looking at session 2, and so we're going to talk about some critically important information there. We talked and touched on some of this in chapter 1, where we talked about tenancy and ownership and some things like that of real property and the transfer of it and so forth. So now we're going to move on, and we'll get into some of this in more detail. One of the things I want to remind you of is that in most marriages, especially in Indiana, we're talking about joint tenancy, okay? And that's where actually both parties own the whole property. It's undivided 100% interest in the property. And so that is a joint tenancy. Now what happens is if parties get divorced and they do not settle how they're going to handle their real estate, it becomes what we call tenancy in common. And so survivorship, and we'll get a little bit more into wills, trusts, and estates again here with property, but the survivorship in joint tenancy, there's automatic right of survivorship. All you have to do is take an affidavit up to the actually recorder's office and the I can't remember what the other person's name is, but up there at the courthouse, and file it with the county, and basically it says that it's the auditor's office, I remember now, and basically it changes then the taxes over into the surviving spouse only if it's joint tenancy. But if it's tenants in common, then basically that's an undivided interest in 50% of the real estate. So that's tenants in common. You both have it. It's a non-described tenancy. That is to say, there's no drawn lines between the two parties, but both sides have a tenancy in common. So in that case, let's say a man and wife get divorced and they own the house tenancy in common, and then one of them dies. Well, then the kids own half of the property and the mother owns half of the property, something like that. So it becomes kind of more complicated in those circumstances. Basically, it would be false to say that a person who has a ownership interest in a joint tenancy with the right of survivorship can will that property to someone else. In other words, let's say that a guy has a girlfriend and then he's married to his wife, and just to get even with her, he wants to write in his will that his half of the real estate that they own by joint tenants will be transferred to the girlfriend when he dies. Well, you can't do that. It's not possible. It's impossible, because there's actually automatic survivorship. You cannot will that. It doesn't pass through the estate. It passes, like I said, automatically to the surviving owner, and all you have to do is notify the county that the other joint tenant has died. So there's no way that you can deed that property or will it to somebody else without the approval and signature of the other party. So in other words, man and wife are one and the same when it comes to joint tenancy of real estate. Another oddball rule, which Indiana is not part of this, is the community property, and that would be in contrast to the joint tenancy. Joint tenancy is true in the majority of states. However, the kind of Spanish rule is the community property, and that's where both sides can transfer off parts and parcels of their property. And so if two people live together as man and wife and then they get divorced, the other person is entitled to 50% of the property, period. Whereas in Indiana, if it's joint tenancy, there's a divorce, then the wife could get the whole house or something like that. Whereas everything is supposed to be divided, community property rules. So, and then the question there is, which way has a majority of states? Do a majority of states follow community property? The answer there is no. It's just a few western states, Nevada, Arizona, California, this type thing. So it's not very common to see community property. But yet it's kind of weird because a lot of people that you talk to think that community property is the actual standard, and it is not true. Basically, tenants by the entirety, that's a different type of situation than joint tenancy. So tenants by the entirety, are required to be married, but that's a different type of setup than joint tenancy. Very similar, not that much different, but they are required to be married. And so it would be false to say that they're not required to be married. In fact, like I said, when you get in these type of situations, basically, if you would get divorced, for example, some of the things automatically shift to tenancy in common, which is a different type of thing that can be owned by different people, boyfriend, girlfriend, father, son, brother, sister, a number of different people can have a tenancy in common ownership. Basically, it is possible to defeat the survivorship in joint tenancy. It can be terminated by divorce. So that's the thing that we've already been talking about. Tenancy by entirety, they always have to be married to each other, just like joint tenants. Okay, so joint tenants, tenancy by the entirety are pretty much very similar, almost the same. The debts of a single common owner can bind his or her interest in real estate, but does not affect, in other words, the whole property or the entire common property. It only affects their share in the property. This can really mess things up, where you've got one person that's like in debt, maybe beyond their means, and they've got an interest in this tenants in common property. Problem you get into, let's say the brother has a bunch of gambling debts, the sister's very frugal, she takes care of her bills, and then the bank or whoever has this gambling debt wants to come back on the guy and say, well, we want the whole property to pay off your debt, and the girl could say, no, you can't, because I own, half of this property. Basically, a general partnership, which can be an ownership type situation in a business, which is a personal property situation, does not require written partnership agreement. I said in the last chapter, I said, that property touches on so many different other subjects. I'm also teaching a class in business organizations, and I just mentioned in the business organizations that you can actually have oral agreements still in partnerships, but it is not recommended. But there are some cases still out there where some pretty large businesses are run as general partnerships on a handshake. And that used to be very good and very common, and it's a positive thing, but the problem you get into now, this day and age, is that it involves banks, it involves debt, it involves creditors, it involves employees, it involves regulation by the government, the IRS, and a number of other things, Social Security. And so if you don't do what you're required to do in respect to the partnership, and it's handshake only, then that can have an adverse effect on your relationship with these other agencies like the government, the bank, different people. So it's almost to the point now where it's a practical reality that you do need a written agreement in your partnership, but there are still some examples of people that have operated without any kind of a written agreement. So to say it's always one way or the other, that's not true. You can still have an oral partnership. Property acquired by a spouse by gift in a community property state is community property. Not necessarily. That's a situation. There's a lot of different things on that. The answer would be false to that statement. In other words, your grandma gives you the farm back in Iowa, but you live in California. And so your spouse in California owns part of that farm out in Iowa. Well, no, that's not true. And so, in other words, going back to what we talked about in the last chapter, the law of real estate in Iowa would control that transaction. And so basically what would happen is they are joint tenancy state, so you wouldn't be in a position where you would have community property having any application at all in the state of Iowa. So this is a really broad statement. Most of the time you'll find when you're looking at some of these true-false questions that if you're given like an overly broad statement, it's probably false. Limited liability companies, here again, this is a form of personal property. It would be ownership in a business. Basically, it says limited liability company can be formed without any type of formal agreement. That would be false. That's not true. One of the important things to understand about limited liability company, it's a lot like a limited liability corporation. Any kind of corporation has to be formed in writing, and those records have to be recorded with the Secretary of State. And one of the important things I would say to you is anytime you want to go into something as complex as a limited liability company, you need legal advice. You shouldn't just try to dream this up on your own. And a lot of times in this day and age, most of the cases I've ever seen, and when I'm in my business organizations class, I would say to you that that book in that class says very definitely that if you're going to go with a limited liability company, you're probably just as better off to go with a limited liability corporation. The actual limited liability company, which is a form of a partnership, is really dying on the vine in the United States. Possible for persons to be general partners in a general partnership without a formal partnership agreement. Like I said earlier, this is true. Any kind of general partnership, you can have a handshake type of agreement. You know, you don't necessarily have to put it in writing, but more and more, practically speaking, if you're going to have a mortgage on the property, if you're going to have you know, receivable debts on, like let's say it's a bar and you got two guys that are sharing the bar and you got all this beer in the back. Well, someone's got to pay for that beer. And so if you're not both signed on the dotted line, there's going to be a problem. So there has to be a lot of written documents, even if there wouldn't be a written agreement. So it's really probably just as well to have a written agreement in this modern day and age. But it is still possible. The broad answer is that it's still true that you could have a general partnership without any kind of written agreement. Next question, spouse's interest in tenancy by the entirety cannot be willed, but it can be inherited. The answer here is false. Basically what they're saying is the only person that can own the balance of a tenancy of entirety is the other spouse, and it passes outside of the estate. It does not even go through the courts. The only purpose in filing that affidavit is to transfer the taxes to the surviving owner. So basically you do not have to get permission from the court in a tenancy by entirety situation where it's a man and wife. The man dies, the wife continues on to own the property. You need to take the husband's name off the property because of his death. And so you sign the papers in an affidavit form and you just record that at the courthouse. You don't have to file it as an estate in the courts and get approval by a judge or anything. You just take it in and inform them that this has happened, and they change the records to reflect that. Okay, property owned by a spouse before marriage is separate property. So basically, in a community property state, somebody owns their own real estate. Then they marry somebody later. That is not community property. That is solely owned by the original owner. So it would be true if you said property owned by a spouse before marriage in a community property state is separate property. Community property is found in only a few states. Remember earlier I told you that. It is true that community property is only found in just a few western states: Arizona, Nevada, California, maybe New Mexico. I can't remember all those, but they have a Spanish influence on them, I will say that. Voluntary division of common property by the owners into separate ownership is called partition. partition. That is P-A-R-T-I-T-I-O-N. What that means is dividing up the ownership of items. So if partners want to divide up the business and go their own way, if a man and wife want to divide up the property as part of an agreed divorce, that would be called partition. Well, here we go into some examples, some actual case study type examples. Aaron, Bob, and Carl, okay? Aaron, Bob, and Carl are joint tenants with right of survivorship owning 15 acres of land, okay? And so what that means is that one of them dies, then the other two own the property. Nobody else, not Aaron's kids, not anybody else. Bob and Carl would own it, okay? And so basically a purchaser wants to purchase 5 acres. And so then basically the answer then is, well, they will need a deed from Aaron, Bob, and Carl. You can't have Aaron say, well, I want to sell off my 5 acres. It doesn't work like that. All three have to agree to it. If one of them doesn't agree, it's not going to happen. Basically, the right of a common owner to be reimbursed from other owners for their share of common expenses is called the right of contribution. The right of contribution, C-O-N-T-R-I-B-U-T-I-O-N. So the right of contribution is the right of one common owner in a tenancy in common to request, require, obtain reimbursement from other common owners. Also, Aaron, Bob, and Carl own property as joint tenants, again with rights of survivorship. During the lifetime of them, Aaron sells his interest in the property to Donna. Bob then dies and wills his property to Frank. Who are the owners of the property after Bob's death? It would be Donna and Carl. So basically, assuming that all three of them signed the deed, now this is the other part that gets confusing. If Aaron sold his property and everybody agreed to this transfer to Donna, then Donna would be an owner, okay? But if Aaron just signed it, which this gets confusing, basically then it gets to be very difficult. And so what would normally happen is if Aaron died and then Bob dies, then Carl would be the sole owner. But because everybody agreed that Aaron could deed over his share to Donna, then the two owners, the answer is Donna and Carl. Okay, so moving forward, which of the following is not one of the unities required by a joint tenancy with right of survivorship? The answer to that one is contribution. Remember that contribution only applies to this tenancy in common. So in other words, common expenses by common owners is contribution. But survivorship, tenancy, joint tenancy with right of survivorship, it does not include contribution. So basically, full liability for debts and obligation of an entity, and that would be all the general partners of a limited partnership. So in other words, a limited partner is kind of like a stockholder in a way. They do not bear liability for the actions of the general parties or the general partners. Only the general partners owe these debts. So liability for debts and obligation of a partnership is actually owed by the general partners, not the limited partners. When we say limited partner, that's what we mean. They're really just an investor. They're kind of similar to a shareholder, although it's not a corporation. Okay, dower, D-O-W-E-R. This is a real estate concept, dower. Now in dower, basically there are certain requirements, and here again this week, 25 points. Investigate dower. Give me about a page on what we mean by the word dower, D-O-W-E-R. Just email that to me as an attachment for 25 extra credit points. So basically what we're looking at, this is part of estate planning, but it's also property that can be owned as dower. So we need to look at that. This also goes into situations with women versus men, and some of this has been overruled in some states, but it would be interesting to get about a page of information on what's the status of dower in our modern society. D-O-W-E-R. So get that to me, I'll give you credit. Tenancy in common, once again, remember it can happen when the real estate is not resolved in the divorce, parties forget or the parties don't want to deal with it in the divorce, then a ownership by the entireties or joint tenancy will shift to tenancy in common. Basically, the only one that can form an agreement for any kind of a business relationship are general partners without any kind of written document. So the same question again from another angle, you can have oral partnerships, okay? So that's the only way though. You cannot have an oral corporation. You have to have written agreements, and these have to be submitted and approved by the Secretary of State for the state that you're filing in. Now you can be a resident of Indiana and you can file a corporation in Delaware. You don't have to be a resident of Delaware. So that's another thing to know. But you would know that if you're in my business class. Concurrent forms of ownership that include a right of survivorship basically is the tenancy by entirety or what we call joint tenant. So tenancy by entirety is the right answer to that. Tenancy by the entirety has the right of survivorship, does not require any kind of estate work or any kind of paperwork other than you do need to file an affidavit to transfer the taxes. Also, which of the following would not be community property? Basically, property received by either the wife or the husband through inheritance. So through inheritance, remember again, like I said, one of them inherits a family farm in Iowa or somewhere like that. That's not controlled by community property laws. Okay, well, last thing we want to cover on this, as another example, we've got Harry and Wilma. They own property as tenants by the entirety. Harry, without Wilma's consent, deeds his interest in the property to Frank. The owners of the property are still Harry and Wilma. So in other words, you cannot deed your interest in property that is owned by tenants by the entirety or by any kind of joint tenancy. Now, tenants in common can deed their property. That's a big difference. But as long as you're married, as long as you own property together, for example, or as long as your deed says right on it, joint tenants or tenancy by the entirety, and a lot of times it says both, then if you have that on there, then that means that nobody else can own that property unless both of you sign the deed. And if Wilma didn't sign the deed, then Harry doesn't own anything. So he's bought the old proverbial pig in a poke. Well, I hope that you've enjoyed this. I know it's kind of dry. Property is kind of dry. But we've tried to help you out by giving you some of the critical information in a kind of a short form. I hope you've been enjoying these comments. I hope that they can help you. You can watch us again as many times as you want. No rules about, oh, well, you only get to watch it once. You can watch it as many times as you need to. We'll be back again with something on session 3 later on. So thanks for paying attention.